justifying the modification of those measures. In the operative clause, the court reaffirmed the provisional measures indicated in its order of January 26, 2024, and indicated additional measures. The court indicated that the State of Israel shall, in view of the worsening conditions of life faced by Palestinians in Gaza, in particular the spread of famine and starvation, take all necessary and effective measures to ensure without delay the unhindered provision of, at scale, by all concerned, of urgently needed basic services and humanitarian assistance to Palestinians throughout Gaza, and ensure with immediate effect that its military does not commit acts which constitute a violation of any of the rights of the Palestinians in Gaza as a protected group under the Convention on Genocide. Today's hearings concern the urgent request filed by South Africa on 10 May 2024 for the indication of additional provisional measures and the modification of provisional measures previously prescribed by the court in the case. The Registrar will now read out the passage from the request specifying the provisional measures which the government of South Africa is asking the court to indicate. You have the floor, Mr. Registrar.
Thank you, Mr. President. I quote, 1. The State of Israel shall immediately withdraw and cease its military offensive in the Rafah Governorate. 2. The State of Israel shall immediately take all effective measures to ensure and facilitate the unimpeded access to Gaza of United Nations and other officials engaged in the provision of humanitarian aid and assistance to the population of Gaza, as well as fact-finding missions, internationally mandated bodies or officials, investigators, and journalists in order to assess and record conditions on the ground in Gaza and enable the effective preservation and retention of evidence, and shall ensure that its military does not act to prevent such access, provision, preservation, or retention. 3. The State of Israel shall submit an open report to the court, A, on all measures taken to give effect to these provisional measures within 1 week as from the date of this order, and B, on all measures taken to give effect to all previous provisional measures indicated by the court within 1 month as from the date of this order. End of the quote.
The Registrar, immediately after the filing of the request for the indication of additional provisional measures and the modification of previous provisional measures, the Registrar transmitted an original copy thereof to the government of Israel. According to Article 74, Paragraph 1 of the Rules of Court, a request for the indication of provisional measures shall have priority over all other cases. Paragraph 2 of the same article states that the court shall proceed to a decision on the request as a matter of urgency. This imperative must, however, be balanced with the need to fix a date of oral proceedings in such a way as to afford the parties an opportunity to be represented at the hearings. Consequently, the parties were informed that the date for the opening of the oral proceedings during which they could present their observations on the applicant's request, had been fixed for Thursday, May 16 at 3 p.m. I would now like to welcome the delegations of South Africa and Israel, and I note the presence before the court of the agents and counsel of both parties. This afternoon, the court will hear the single round of oral argument of South Africa, which has submitted the request for the indication and modification of provisional measures. It will hear Israel tomorrow morning at 10 a.m. For the purposes of the single round of oral argument, each party will have available to it a 2-hour sitting. In this first sitting, South Africa may, if required, avail itself of a short extension beyond 5 p.m. today in view of the time taken up by these introductory remarks. Before I give the floor to the agent of South Africa, I wish to draw the party's attention to practice direction 11 Roman, which state as follows, I quote, "In the oral pleadings and requests for the indication of provisional measures, parties should limit themselves to what is relevant for the criteria for the indication of provisional measures as stipulated in the statute, rules, and jurisprudence of the court. They should not enter into the merits of the case beyond what is strictly necessary for that purpose." I now give the floor to the agent of South Africa, His Excellency Mr. Vusimuzi Madonsela. You have the floor, Excellency.
Mr. President, distinguished members of the court, it is an honor and a privilege for me to appear before you on behalf of the Republic of South Africa. I wish to thank the court for setting this matter down for an oral hearing on the earliest possible date, recognizing the extreme urgency of its circumstances. Since its initial application, South Africa found itself compelled to return to this court, both in February and March 2024, to request for the indication of additional provisional measures to prevent Israel's persistent acts of genocide against the Palestinian people in Gaza. Sadly, South Africa is yet again compelled to return to this court in recognition of its obligation under the Genocide Convention due to the continuing annihilation of the Palestinian people, with over 35,000 now killed and most of Gaza reduced to rubble. Despite the short notice, South Africa has traveled here today to do what it can to urgently stop the ongoing genocide. The gravity of the attacks requiring urgent and speedy proceedings to preserve the rights of the Palestinian people, a commitment which South Africa takes seriously. Israel is escalating its attacks on Palestinians in Gaza, and in so doing is willfully breaching the binding orders of this court. Israel similarly breaches the binding resolutions of the United Nations Security Council, erroneously believing from the lack of countermeasures by the international community that it is exempt from having to respect international law. This institutionalized impunity has led Israel to engage in this genocide, which has shocked the conscience of humanity. South Africa is mindful that the present genocide operates in denial of the Palestinian people's inalienable right to self-determination and collective right to return to their homes in Palestine. This genocide takes place within the context of the ongoing Nakba, the 76th anniversary of which was celebrated yesterday. A continued forced displacement of the Palestinian people, the erasure of Palestinian presence in Palestine, and replacement with colonial settlers. A criminal process entrenched and maintained by 76 years of apartheid and 56 years of illegal, belligerent occupation. Undoubtedly, the ongoing scenes of Palestinians being forced to repeatedly flee for their lives is only reminiscent of the Nakba of 1948. It is a continuation of it. 7 months ago, South Africa could not have imagined that Gaza would now be mostly wiped off the map. It could not foresee that every family, every neighborhood, every class of students, every workplace would be pulled apart, killed, maimed, displaced, malnourished or starved. South Africa had hoped, when we last appeared before this court, to halt this genocidal process, to preserve Palestine and its people. Instead, Israel's genocide has continued apace and has just reached a new and horrific stage. Israel has sought to hide its crimes through the weaponization of international humanitarian law. It pretends that the civilians it ruthlessly kills through its 2,000-pound bombs, through its targeted airstrikes, through its artificial intelligence systems, through its executions, are human shields. This whitewashing of Israel's genocide misses the key and fundamental element, that of the massive and still mounting evidence of Israel's genocidal intent. Documents and videos of Israeli parliamentarians and military leaders calling for the destruction of the Palestinian people in Gaza. Incitement by Israeli civil society and leading public Israeli figures, all collectively supporting the genocide and its continuation. Israel continues to show utter contempt for Palestinian life, operating with impunity. South Africa has no other option than to once again seek protection in the halls of justice for the fundamental right of the Palestinian people to their existence. Although this present application was triggered by the unfolding horrific situation in Rafah, Israel's genocidal onslaught across Gaza has intensified over the past few days, also warranting the attention of this court. With that, Mr. President, I respectfully wish to request you to invite Professor Von Loh to set out South Africa's substantive legal arguments. I thank you.
I thank the agent of South Africa for his statement. I now invite Professor Von Loh to take the floor. You have the floor, sir.
Thank you, sir. Mr. President, members of the court, it is a privilege to appear before you and an honor to have been entrusted with the presentation of this part of South Africa's submissions. This is not a routine case. It's not even a routine case on the use of force or on international humanitarian law. South Africa is here because the Palestinian people are facing genocide in Gaza, and your previous orders have not succeeded in protecting them against that. The court held in January that the Palestinians have a legal right to protection against genocide. and that South Africa had shown that there was a real and imminent risk to the irreparable violation of that right. The court issued an order because it considered it necessary to protect the Palestinian people against genocide, and it issued a further order in March. But whether because of a lack of clarity as to precisely what the orders require, or because Israel chooses to ignore them, they have not been effective. The United Nations has a framework, including the Security Council and the General Assembly, for addressing international disputes. But this part has not worked well in this case. And South Africa respectfully asks the court to reassert its authority and its role in this framework. South Africa has considered the technical legal requirements for provisional measures, change in the situation and so on, and will address them. The point is that the court has the power to act, to ensure that its previous orders and its eventual judgment will not be worthless, and that the Palestinian people will be protected, and that it needs to exercise that power now. Israel's action is directed against the Palestinian people throughout Gaza and the West Bank. South Africa's request was initially focused on Rafah because the imminent prospect of death and suffering on a massive scale resulting from Israel's attack. But since that request was made, it has become increasingly clear that Israel's actions in Rafah are part of the end game, in which Gaza is utterly destroyed as an area capable of human habitation. This is the last step in the destruction of Gaza and its Palestinian people. It was Rafah that brought South Africa to the court, but it is all Palestinians as a national, ethnical, and racial group who need the protection from genocide that the court can order. We've heard expressions of outrage that anyone could accuse Israel of acting in this way. We've heard assurances that Israel was doing everything in its power to avoid civilian deaths as it exercised its claimed right of self-defense. We've heard boasts that Israel's army is the most moral army in history. And we've heard denials that there is famine in Gaza. For months, people, particularly in the West, have appeared unwilling to accept that the accusations are true. How could people who look like us and sound like us possibly engage in anything like genocide? But the evidence has to be faced. My colleagues will take you to that evidence, including evidence of continued bombings, attacks on people in so-called safe areas to which they've been directed by Israel, attacks on aid convoys, and of mass graves and the horrors of which the corpses speak. There is no credible argument that this catastrophe is not real. The court has already found a real and imminent risk of the violation of the rights of the Palestinian people to protection against genocide. The court is aware of the statements of the United Nations Secretary General, of the President of the United States, of heads of state and foreign ministers from around the world, and of the heads of international aid agencies. They, and the personal accounts and the news footage that emerges from Gaza, tell a consistent story of unimaginable horror. And it continues as we speak. Most of Gaza has been razed. The survivors who are from time to time allowed to return to their homes are returning to rubble, with no homes, no running water, or electricity, or sewage, or other working infrastructure. And with the few possessions that they've managed to carry with them on carts or cars as they're pushed from one so-called safe area to the next. If the court does not act now, the possibility of rebuilding a viable Palestinian society in Gaza will be destroyed, at least for the lifetime of those who survive the current horrors of Gaza. The details are not always easy to verify because Israel continues to bar independent investigators and journalists from entering Gaza. And over 100 journalists who were in Gaza have been killed since the Israeli attacks began. But Israel cannot block investigations by independent investigators and then say that the court cannot proceed because there is insufficient evidence against it. The court has to deal with this case on the basis of its appraisal of the best evidence available to it. Israel may again invoke its claimed right of self-defense, but it does not address three glaringly obvious points. First, the right of self-defense does not give a state a license to use unlimited violence. No right of self-defense can ever extend to a right to inflict massive, indiscriminate violence and starvation collectively on an entire people. Second, nothing, not self-defense or anything else, can ever justify genocide. The prohibition on genocide is absolute, a peremptory norm of international law. Third, the court ruled in 2004 that there is no right of self-defense by an occupying state against the territory that it occupies. The key point today is that Israel's declared aim of wiping Gaza from the map is about to be realized. Further, evidence of appalling crimes and atrocities is literally being destroyed and bulldozed, in effect wiping the slate clean for those who've committed these crimes and making a mockery of justice. The court is not powerless, and South Africa submits with respect that it must do something to assert not only its own authority, but the authority of international law. South Africa submits that in order to secure the entry and distribution of food and humanitarian supplies and to save lives, a halt to Israeli military operations across Gaza is essential. The overwhelming weight of opinion among states and international organizations is the same. A halt to military operations in Gaza is necessary to comply with the previous orders that the court has already imposed. If Israel continues to deny that its bombing and shelling and military incursions and blocking of roads and entry points and its other military operations in Gaza are preventing the fulfillment of the court's orders, the court needs to spell it out explicitly for Israel and for the benefit of any other states that are still providing aid or assistance to Israel in its campaign to eradicate Palestine. These points will be developed by South Africa's counsel. First, John Dugard will explain the jurisdictional and other preconditions to the exercise of the court's power to order provisional measures and demonstrate that they are met. Second, Max du Plessis will set out the recent events that have necessitated South Africa's return to the court, and particularly those concerning Rafah. Then Adila Hassain will explain the scale and imminence of the risk facing Palestinians in Gaza. And after that, Tembeka Kokutobi will show that Israel's actions have a pattern and an explicit purpose that clearly indicates that the aim is to eradicate Palestine. And finally, Lina Negroli will explain the remedies that South Africa seeks. And the agent will return to read out South Africa's prayer for relief. That, Mr. President, members of the Court, concludes my part of this submission, and I thank you for your attention and ask that you now call on Professor Dugard.
I thank Professor Van Loo for his statement. I now give the floor to Professor John Dugard. You have the floor, sir.
Mr. President, distinguished members of the Court, it is a privilege to be before you on behalf of the Republic of South Africa. In my speech today, I will briefly address the subject of jurisdiction and then examine the circumstances that give rise to our request for further provisional measures. In its order of 26 January of this year, the Court found that the applicant had prima facie established the existence of a dispute between it and the respondent relating to the application of the Genocide Convention, and that the Court had jurisdiction in terms of Article 9 of the Genocide Convention. In its order of 28 March, the Court found that there was no reason to revisit this decision. It is submitted that this conclusion remains valid for the present proceedings. The Court also found that Palestinians in the Gaza Strip have a plausible right to be protected from acts of genocide, and that South Africa had the right to seek compliance with this obligation. Again, the Court declared that this finding need not be revisited in its decision of 28 March. Again, it is submitted that this conclusion remains valid. The Court has found that South Africa has advanced a plausible genocide claim. On 26 January, the Court found that the situation in Gaza was one that required urgent attention and that there was a risk of irreparable prejudice. This was confirmed in the order of 28 March, and it is a situation that continues today. Indeed, it is further heightened now in the context of Israel's brutal attacks on Rafah and subsequent intensified bombing across the north and middle areas of Gaza. Mr. President, on the basis of the above findings, the Court ordered a number of provisional measures on 26 January. On 28 March, the Court found that the circumstances of the situation had changed in terms of Article 76 of the Rules of Court as a result of the risk of famine, and ordered 3 more provisional measures against Israel. Today, Mr. President, South Africa approaches the Court for a new provisional measures to ensure that the rights in issue in the proceedings, including the right of Palestinians to be protected from acts of genocide, will be protected. The rules of court allow the Court to order new provisional measures when new facts are established or there has been some change in the situation which justifies modification of the existing orders. It is, of course, impossible to provide an absolute definition of new facts or change in the situation, as it is necessary to have regard to the situation in each and every case. Decisions of the Court involving provisional measures have dealt with a change in the situation arising from new facts in completely different circumstances. Cases have dealt with matters of life and death, territorial change, and freedom of movement. Each case depends upon its own set of facts, and whether these facts have so altered the situation that new provisional measures are justified on the part of the court. In issuing its March order, the court considered that developments since January 2024, which it found to be exceptionally grave, constituted a change in the situation within the meaning of Article 76 of the Rules of Court. It also found that the previous provisional measures that it had indicated did not fully address the consequences arising from the changes in the situation. And this led the court to order further provisional measures. The changes in the situation since March of this year are in many ways graver still. They too justify the indication of further provisional measures. On 26 January this year, this court found that there was a catastrophic humanitarian situation in the Gaza Strip, which was at serious risk of deteriorating further before the court renders its final judgment, and this warranted provisional measures. On 28 March, the court found that the catastrophic living conditions of the Palestinians in the Gaza Strip have deteriorated further, in particular in view of the prolonged and widespread deprivation of food and other basic necessities. Mr. President, members of the court, it is difficult to imagine that the situation could get worse, but unfortunately it has. In the early days of the Gaza war, Israel forced Palestinians to relocate to the south, to the Rafah Governorate. 1.5 million people were crammed into this inhospitable area in the Rafah Governorate, which appeared to offer safety from Israel's bombing, artillery fire, and the brutality of its forces, influenced by genocidal incitement by its leaders. World leaders warned that an assault on Gaza, and in particular on Rafah, resulting in the forced and arbitrary evacuation of the already displaced Palestinians to even less hospitable parts of Gaza without adequate food, water, shelter, and hospitals would have disastrous consequences. The Director General of the World Health Organization declared that a military incursion into Rafah will plunge the crisis into unprecedented levels of humanitarian need. A ceasefire is needed for the sake of humanity. Israel, Mr. President, has not heeded this warning. It has not even fulfilled its own undertaking not to embark on an assault on Rafah without a proper evacuation plan. Instead, it has gone ahead and embarked on an attack on Rafah. The Rafah Governorate has been bombed, subjected to artillery fire and ground incursions. The Rafah crossing is closed, and the Kerem Shalom crossing is mostly disabled. Mr. President, my colleagues will provide you with a full account of Israel's genocidal acts in the Gaza Strip. It is my task to briefly indicate the new facts required by Article 75(3) and the change in the situation required by Article 76(1). Mr. President, this application for further provisional measures is prompted by Israel's assault on Rafah. It is this assault that constitutes the new facts, the change in circumstances. Rafah is the last refuge in Gaza for 1.5 million Palestinians, the majority of whom have been forcibly displaced from north and central Gaza. Rafah is the last viable part of Gaza for rehabilitation, public administration, the provision of basic services, and medical care. Israel has now commenced its long-threatened assault on Rafah. It has ordered the evacuation of Palestinians in Rafah to the barren sand dunes of Al-Mawasi. It has closed critical border crossings to humanitarian aid, medical supplies, goods and fuel, upon which the population of Rafah depends. Displacement, famine, and suffering are now the lot of the Palestinian group. Israel's actions are in violation of fundamental rules of humanitarian law, but in addition, they provide evidence of the crime of genocide in terms of Articles 2, A, B, C, and D of the Genocide Convention. Mr. President, members of the Court, this attack is the final blow that is intended to destroy the Palestinian group in Gaza. That this is the intention of the final operation will be made clear by Mr. Nkwakhobi. Mr. President, since South Africa filed the present application for provisional measures, Israel has intensified its offensive in the north and in central Gaza. In these circumstances, we have requested the Court to issue a provisional measure that orders Israel to cease its military activities throughout Gaza and to withdraw from the territory. Such an order alone can bring an end to Israel's genocide in Gaza. That the Court has the power to order such a provisional measure is clear. The Court has stated that in terms of Article 75(2) of the Rules of Court, it has the power under its statute when a request for provisional measures has been made to indicate provisional measures that are in whole or in part other than those requested. Mr. President, members of the Court, this concludes my speech. I thank you for your attention.
I thank Professor John Dugard for his statement. I now give the floor to Professor Max Duplessis. You have the floor, sir.
Mr. President, distinguished members of the Court, it's a privilege to appear before you on behalf of South Africa. My task is to address this Court on the new facts and the grave changes in the situation in Rafah that is fast leading to the deadliest phase in this ongoing genocide. Those are the circumstances that compel South Africa to return to the Court to seek urgent further or modified provisional measures against Israel. Judges of this Court have recognized that the underlying reason for the Court's January and March orders was that the very right of existence of the Palestinian population in Gaza is currently at risk of irreparable prejudice, and that the only effective way of preserving the right of existence of the protected group is through the function of prevention. South Africa seeks these provisional measures before it's too late for prevention to be possible, let alone effective. This Court noted that the situation in Rafah was already perilous in its decision of 16 February. And instead of complying with this Court's decisions of January, February, and March, Israel has defied this Court by trapping, besieging, and bombarding an overcrowded Rafah, exacerbating the security and the safety of 1.5 million highly vulnerable Palestinians. Mr. President, no one in Gaza is safe because, as the United Nations has repeatedly made clear, nowhere in Gaza is safe. Palestinians were instructed by Israeli evacuation orders to move south to Rafah, and seek refuge there from the bombardment in the north. Yet for months, the expanding population scrambling for refuge in Rafah has been explicitly told by Israel that they are not safe, and that Israel does not intend for them to be safe. The international community has witnessed Israeli soldiers preparing for the ground invasion of Rafah, filming themselves, chanting, "Tear down Rafah." And Israel's intention is typified by statements such as that of Israel's Minister of Finance, Mr. Smotrich, a member of the Security Cabinet, who has explained, and I quote, "There are no half measures. Rafah, Deir al-Balah, Nusayrat, total annihilation. You shall blot out the remembrance of Amalek from under heaven. There's no place under heaven." Close quote. Mr. Toby will deal in careful detail with intention that is so clearly evident in such statements and by Israel's conduct. Now, Israel has resolutely resisted all international efforts to persuade and cajole it from eventually attacking Rafah. As we contemplate the horror of recent events and the significance of Rafah for Israel's ongoing assault, the reminders regrettably of Srebrenica come into view. Rafah's prominence in the eyes of both the Palestinians and the international community, the safe areas in Gaza, which has received significant attention in the international media. To paraphrase